Yeah.
is how do you prove intent? There's a case where it was into the trust, out, in, out. And so he went to a paralegal who said, you really can't prove intent, therefore it's not worth pursuing. And I said, I would accept that answer. I'd want to talk to an expert like you before I gave up on it. So can you share with us, and again, just to recap, a Heggstad is when the property was maybe at one time or should have been or might have been in a trust, and it's not at the time of death. And so there's a petition to consider the property that's not in the trust. And you really ask the judge to put it in the trust. So how do you prove the intent in a case like that?
Well, the intent has to be proven with a Heggstad petition. It has to be proven by the document itself. So, I mean, Heggstad relied on the fact in that case, the judge relied on the fact that Mr. Heggstad put on the schedule of assets that he had at the back of the trust a list of those properties that he intended to include in the trust. And one of those properties was the property they were trying to get in by the Heggstad petition. So the court recognized Mr. Heggstad's intent by the very document, and therefore issued the order granting that petition. Basically, the attorneys were asking, Your Honor, we believe that by putting that on the schedule, that was a transfer to the trust. We didn't need to do it by deed. We think that is sufficient, and we want the court to give us an order that states that. And the court did it. The court granted that petition. That's what set the precedent back in 1993. And so now what you need is the document itself. So the sad thing is that I would say, most trusts do not have adequate provisions for that. So what you need is a schedule of assets that has a list of those assets in the trust, in the document itself, or maybe an assignment separate from the trust, some document that states the intent that the person intends to include these assets in the trust. Even a general statement of intent. With Heggstad later, a case that followed Heggstad, that said even a general statement of intent regarding all my real property I intend to be part of the trust would be sufficient. So as long as the trust has some language like that, even if there is no schedule, but in the document itself, it references the property, like I'm leaving my property to so-and-so, even that would be sufficient. The judges are really just looking for something to hang their hat on, where it would show what the intent was. And even in situations where somebody refinanced the property, took it out of the trust, we said, look, this is the reason why they did that. They did it obviously for financing purposes. Here is the deed of trust that shows they were refinancing at the time they took it out. And therefore, all of that information is sufficient. And I can't remember a case now, it's been many, many years, a case now where if you didn't have some evidence of intent within the trust, that the court didn't approve it. So our luck has been, I mean, I wouldn't call it luck. I would say we give sufficient information in that Heggstad petition for the court to rule in our favor. Very rarely, even in situations where it's just some little statement about real property, we can get it in there. The court's looking to do that as long as nobody's going to object to that, and most of the time they don't. There's really no reason to object, because otherwise it's going to get in through the trust anyway, through a probate, right? Because you typically have a pour over will that says, if I leave something out, I leave it all to my trust, it's going to end up in the trust anyway. So why not avoid a probate if we can, using the Heggstad petition? So it's got to be in the document itself. And I will tell you, many situations, I would say probably in most situations, there isn't that intent in the trust. There isn't a schedule of assets. Or maybe the schedule of assets is something that was there when they signed the trust, and it only lists property that they had at the time they signed the trust. And this is 10, 15 years later when they've acquired other property. They acquired these properties or this property after they created the trust, and so it's not on the schedule. But in our schedule of assets, we say not only these things that I own today, and I list everything that they own at the time they signed the trust, we do a catch-all at the end that says not only these things, but anything else I may acquire in the future, such as real estate, investments, timeshares, corporations, stocks, bank accounts, a non-exhaustive list of things I may acquire that would also be intended to be part of the trust. So even in those situations where a client acquires something later and just forgets to put it in the trust, even those we can get into a Heggstad and have successfully. So yeah, I mean, so that's how you prove intent. You prove it through the document itself.
So if I can, just for those of you watching who are maybe not as involved as I am on this regularly, two things should be clear to you. One, this is why you went to Paul Velasco to write your estate plan, because he knows the perils and pitfalls of bad plans as a litigator, and that's why he corrects his documents going forward on the front end. I know that I don't want to make this an advertisement for you, but I just want to point that out. And second, you hear the clarity when he describes this. I would say you could go to 10 attorneys and ask the question. And a bunch of them are going to say it's impossible. And a bunch of them are going to give the answer Paul did. And that's why you're going to a professional who knows this as an area of expertise versus a general attorney who may not know it. That if you have that material, then you can speak with authority. So thank you, Paul, for sharing that.
Yeah, and just, to help those estate planning attorneys who draft these trusts, the other thing that we do, in addition to the schedule of assets, which is what Heggstad relied on, we also do a statement of intent. Intent in the probate law, in the probate world, is key. It's important. It's significant because anytime there's a problem with the trust, either because it's not clear, it's ambiguous, if it can be shown in there what they were trying to do, if a judge can discern what they were trying to do by a statement of intent, well, all the better. And so in all of our trusts, we have, and ever since the beginning, I've been doing this for 25 years, and Heggstad's been around since before me. So I've used this all the time in my trust statement of intent that says, look, my primary purpose in doing this trust is to have a plan for distribution of my estate when I pass away. The secondary purpose is to avoid probate. And therefore, I intend to leave all my assets in my trust throughout my lifetime. But if I make a mistake, if I inadvertently leave something out, then I want the court to issue an order at my death, like they did in that case, the estate of Heggstad and its progeny, Heggstad and others, to leave that as part of my trust, to make an order that is part of my trust and avoid probate. So that statement of intent is in the very front. The judge sees that, well, of course they're gonna give us the order, because even if we have just a minimal amount of intent, that's what they intended, to avoid probate. So never in the 25 years I've been doing this, not one time has one of my trusts had to be probated because somebody made a mistake. And my clients make mistakes too. People do. They acquire new things. They forget to put things out of the trust. When they refinance, many situations it comes out of the trust, they don't even know that it came out of the trust. In all the documents that people sign for refinancing, one of them is a deed that puts it back into their name and they didn't even know it. And then it just never gets put back. And so mistakes happen. But as long as you have provisions in the trust that allow you, and I know my clients are going to make mistakes, then we can still get it into the trust later without probating. It's a huge time saver and, of course, cost savings too.